Chapter 8, Criminal Law. Why learn criminal law? You likely considered this question at the beginning of this semester as you reviewed the syllabus. This is a business law class. What's the point of learning criminal law? The first and best reason to learn criminal law is that going to jail is not a good time. Jail isn't just full of bad guys, and it's not abnormal for good people who've had a bad day to allow a lapse in judgment to do something that lands them in jail. Another reason we study criminal law is because, as you'll see shortly, we have laws called strict liability laws. These laws can land you in jail even if you are mistaken in your interpretation and understanding of the law. Indeed, the violation of a strict liability law might well land you in jail when you are actively trying to do the right thing. Third, there are many different criminal laws specific to those in the business world created by administrative agencies. These laws are going to be found in the Code of Federal Regulations, the CFRs, and your state's equivalent. These are incredibly expansive and very difficult to search when compared to statutes. The last reason we learn criminal law is because understanding criminal law and how to interpret statutes is one of the best ways to develop the analytical mindset necessary to start thinking like a lawyer, which will pay dividends when understanding other laws or how to run your business in line with the law. Overview of the American criminal justice system. The American criminal justice system is not perfect. No one nation's is. If you pay attention to the news, I'm sure you're already well acquainted with instances of improper treatment of citizens by law enforcement in the court system. But the ideas our system espouses and the standards we strive for are exceptional and revolutionary, even amongst other advanced nations. The American system is designed to ensure that the individual citizen cannot be railroaded unjustly by the government. This wasn't some fanciful notion that leapt from the heads of the Founding Fathers spontaneously. Our criminal protections came largely as a response to specific abuses American colonists suffered at the hands of the British government. In the American criminal justice system, you are innocent until proven guilty. Like with a civil case, the burden is on the plaintiff. In a civil case, the plaintiff is normally another private citizen. In a criminal case, the plaintiff is the government. In both cases, the default position is that the accused needn't prove anything. The burden is on the one doing the accusing. All else being equal, the presumption is that the cops got the wrong guy. You don't even have to get on the stand. This is your right against self-incrimination enshrined in the Fifth Amendment. You can sit there and raise absolutely no defense at all. The burden is on the government. Not only is it the government's job to prove your guilt, but they must do so beyond a reasonable doubt. This is the highest burden of proof there is in the legal system. On page 191, I give you a chart of the different burdens of proof. If a jury is pretty sure you are guilty, or if the jury thinks you're probably guilty, then they must find you not guilty. There are different explanations for this term, but if we were to operate under a percentage scale, we'd likely define beyond a reasonable doubt as somewhere in the 97-98% range. The state needn't prove guilty beyond all doubt because there will always be some sort of crazy explanation that could potentially exist out there. Who's to say, for example, that a shape-shifting alien didn't do the crime, or that the real culprit paid off 50 witnesses to testify against you? I know everyone wants to laugh about aliens until the probes come out. Then it's not so funny, is it? But if you have a normal, rationally explainable, reasonable doubt about the defendant's guilt, then they must be found not guilty. Lastly, we have specific amendments in the Bill of Rights, rights deemed fundamental by the court and the people that protect the criminally accused. The Fourth Amendment protects us all from unreasonable searches and seizures. The Fifth Amendment protects your right to remain silent, ensuring that you cannot be forced to testify against yourself. It also ensures that you cannot be tried again if you are found not guilty, something known as double jeopardy. The Sixth Amendment is full of various rights for the criminally accused. The right to a speedy, public jury trial by a jury of your peers, the right to confront your accuser, the right to legal representation, and the right to have witnesses be required to testify in your defense, even if they don't want to, something called compulsory process. Lastly, the Eighth Amendment protects us from unreasonable bail and cruel and unusual punishments. What is a crime? When a person commits a crime, they have violated a duty to society at large. Previously, we talked about intentional torts, where you have violated a duty to another individual. With a crime, you are not being punished for what you've done to the victim, but rather because you've broken one of society's rules. Many crimes, particularly where there is a clear victim, might also be an intentional tort. In many cases, the prosecutor will request restitution from the victim, but if they do not, the victim can always sue for damages in civil court. Crimes can be found scattered throughout our legal system. Most crimes can be found in the state and federal penal code. However, crimes and punishments can be found in treaties, local ordinances, and tucked away in the various administrative codes or regulations, the CFRs. Differences in criminal and civil law. While there is some overlap between criminal and civil law, a few areas should be given specific attention. Two notable differences are the burdens of proof and the parties involved. As mentioned at the beginning of this chapter, to find a person guilty, their guilt must be proven beyond a reasonable doubt. This is a very high, about 97 to 98% burden. In a civil case, liability or responsibility must be proven by a preponderance of the evidence. This is anything over half and can be as low as 50.1%. Therefore, you can have cases like the famous O.J. Simpson murder trial, where O.J. is found not guilty of murder, but is later sued for his wife's death by her estate and found responsible and required to pay several $million. The language is important here. Guilt is for criminal cases, whereas responsibility or liability is for civil cases. So a person will not be guilty for breach of contract, nor will he be liable for murder. The parties will also be different between civil and criminal law. In a civil case, the two parties will be suing each other for a non-criminal matter, and generally, but not always, will be two private entities. It might be citizen versus citizen, business versus business, government versus government, or any combination of the above. In a criminal case, it will always be the government versus you. If you're being charged under a local ordinance, the caption on the paperwork will say, the city of Belaw versus knucklehead student. If it's a state law, it will state, the state of Belaw versus knucklehead student. And if you're being charged for a federal crime, it will read, the United States of America versus knucklehead student. Now that doesn't sound intimidating, does it? In a criminal case, the government is represented by a prosecutor. Sometimes in court, the prosecutor will refer to the government as the state, and in front of the jury, they will often refer to themselves as representing the people, as this generates a more sympathetic response. While a prosecutor is technically the lawyer for a government by and for the people, with this little bit of verbal jujitsu, they carry themselves as the heroic representatives of society, as opposed to the agent of a powerful government mobilizing its resources against an individual citizen. The defendant will be represented either by themselves, a private practice attorney, or a public defender. Any defendant with capacity has the legal right to defend themselves. This is referred to as pro se and should be very strongly discouraged. Even experienced criminal defense attorneys know not to defend themselves if charged with a crime. A defendant not well versed in the law is likely to miss important facts, make serious legal errors, use bad or outdated case law, or make other damaging mistakes. Even a person knowledgeable in the law is likely to struggle with handling their defense in an objective manner and can easily fall in love with their own argument, missing serious gaps in their case. In most jurisdictions, a public defender is not guaranteed. You are granted a right to legal representation as part of the Bill of Rights. But as the Miranda rights state, a public defender is only provided if you cannot afford a lawyer. The court will make that determination during your first appearance in front of a judge. If the court believes you can afford a lawyer, you will be required to use a private practice attorney or defend yourself. How to classify crimes. Every state has its own classification system of crime. Most break down to three main classifications: felonies, misdemeanors, and infractions. However, some states will have more than this, such as Class A, B, or C felonies and gross misdemeanors. The primary effect of these additional classes is to narrow sentencing windows for judges. Crimes also fall under those considered mala in se and malum prohibitum. Lastly, we categorize crimes as intent, non-intent, and strict liability crimes. Felonies, misdemeanors, and infractions. A felony is a crime that can result in a year or more in prison. This does not mean that it will result in a prison sentence of a year or more, only that it can. It is not uncommon for a person to be convicted of a felony and spend a week or so in jail. The primary difference between prison and jail is that prisons are operated by the state or federal government and is only for people who have been convicted, whereas jail is most often operated by the county and is for people with short sentences and for people waiting for their trial who haven't been convicted of anything yet. Most states that do not divide their felonies up into subclasses will provide specific sentencing parameters in the statute for each specific crime and a maximum sentence for a generic felony, such as 1 to 5 or 1 to 10 years. In states that have subclasses, such as Class A, B, and C felonies, each class will have a sentencing window, such as 1 to 5 years for a Class C, 5 to 20 years for a Class B, and life imprisonment to execution for a Class A. In most jurisdictions, misdemeanors are crimes that provide for sentencing in the county jail of up to 6 months. In some states, it's only up to 3 months, and in others, it's up to a year. Like with felonies, this does not mean that you will go to jail for 6 months, only that you can. Many misdemeanors result in a fine, but the judge has the discretion to increase that jail time. Some states have gross misdemeanors, which are more serious and fill the sentencing gap between misdemeanors and felonies, generally 6 to 12 months. Lastly, we have infractions. These are punishable by a fine only. Infractions would be things like speeding tickets or, as I'm prone to getting pulled over for, running red lights, because I feel like an idiot for sitting at a red light when there's no one there, so I run it. But infractions aren't limited to driving crimes. Some states haven't completely legalized things like marijuana or underage drinking, but instead have moved them to infractions, allowing you to pay a fine instead of facing possible jail time. Mala in se and malum prohibitum crimes. When we think of criminals, we often think of bad people who do bad things, such as murder, rape, robbery, or similar crimes. These sorts of acts are considered mala in se crimes. This is Latin for bad in itself. We're all familiar with the statement that ignorance of the law is no excuse. This phrase can be traced back to ancient Rome when there were far fewer laws on the books, and most of those laws were considered mala in se. These are the types of laws that no one needs to tell you exist. Even if your parents failed to teach you the difference between right and wrong, odds are that you instinctually know not to behave this way. These sorts of laws also often have a very clear victim. A person could not travel to Paraguay, murder someone, and then expect the courts to believe that you were unaware that murder was unlawful. A Washington resident on vacation in Vermont could not fund their trip by robbing gas stations and then tell a jury that they didn't know it was against the law because they hadn't seen the state's penal code. Something being mala in se is no guarantee that a crime exists. There are many things commonly considered unethical, like adultery, or not putting your shopping cart back, seriously, what gives, that are not illegal. Most common on the books today are malum prohibitum crimes. These are wrong because they're prohibited. A person might not know instinctually that something is immoral or wrong. However, the courts will still apply the maxim that ignorance is no excuse for violating these laws. Malum prohibitum laws do not always have a clear victim, and the law basically exists because I, the lawmaker, say so. Malum prohibitum laws are added to the books all the time. These might be things like fireworks bans or the recent increase of the age for the federal use of nicotine products from 18 to 21. Laws determining the caffeine content in a drink, requiring you to wear a seatbelt, allowing men but not women to be topless in public, banning sales of liquor on Sunday, or determining how and where license plates must be located on your car are all examples of malum prohibitum laws. Whether a law is mala in se or malum prohibitum has no bearing on whether the law is classified as a felony, misdemeanor, or infraction, but it often determines in the court of public opinion whether something should be a crime in the first place, since many malum prohibitum crimes don't have a clear victim. Intent, non-intent, and strict liability crimes. Intent crimes are crimes that you must intend to do. You cannot be convicted of an intent crime by accident. You don't necessarily need to know that the act was illegal, but you do need to have intended to do the bad thing that you did. An intent crime consists of two elements: the actus reus and mens rea. The specific rule laying out the crime is not going to tell you what type of crime it is, so you need to determine this by reading the law's text. An intent crime is best identified by the words intentionally, willingly, knowingly, or similar language. Most, but not all, intent crimes are mala in se. The actus reus of the crime is the bad act. If a person is being accused of murder, but the victim is walking around, then there is no bad act. No one was killed. The mens rea is the bad mind. This is the real element that makes a crime an intent crime. If someone runs out in front of you while you're driving and you run them over by accident, you still haven't committed murder. You did engage in the actus reus. You did run that person over, but you didn't intend to kill anyone. Mens rea is the bad mind. There are two types of mens rea. Specific intent means that not only did you intend to do something bad, but you sought out the bad result as well. I decide that I do not like you and I want to kill you, so I stab you until you are dead. The alternative is general intent. This means that I did intend to do some bad stuff, but I didn't necessarily intend the bad outcome. I decide that I don't like you, so I punch you. You fall, crack your head open on the concrete, and die. I intended to hit you, but I never intended to kill you. Different crimes may include different elements. For specific intent, first-degree murder might attach, whereas for involuntary manslaughter, only general intent might be necessary. I intended to go to the bar. I intended to get drunk. I intended to get behind the wheel. I never intended to kill anyone, but I run them over negligently. Non-intent crimes are those that are committed by negligent or reckless behavior. It is unnecessary for a finding of specific intent to convict someone of a non-intent crime. Lastly, we have strict liability crimes. These require neither negligence nor any intent whatsoever. In fact, even if you go out of your way to do the ethical thing and the right thing is what violates the law, you can be found guilty of the crime. These are overwhelmingly malum prohibitum crimes. Your friend has a meth problem. You take the drugs away from him and plan on taking it home to flush it. On the way home, you're stopped by the police and he finds the drugs in your possession. You are guilty. You meet someone at a bar. You go back home with them and have sex. You find out in the morning that that person was 17. You are guilty of statutory rape. Your argument that the person was in a bar and couldn't have been under 21, while logical, has no bearing on whether you committed the crime. How to read a criminal statute. In this next section, we will review several different crimes that fall under traditional common law. Then we will review some specific crimes that people in business are occasionally convicted of. Every jurisdiction will word their statutes differently, and some of the following definitions will seem absurd. The reason this is being discussed in a class about business law is to help illustrate how to read a statute, not to know the definitions of crimes unrelated to business. When reading a law, you need to be able to parse out the material elements. These are the specific important elements, and each must be proven beyond a reasonable doubt by the prosecutor to secure conviction. For example, the common law definition of murder is the unlawful killing of a human being by another person without justification. So if you're being tried for murder, when the jury deliberates at the end of the trial, the question is not going to be, did you commit murder beyond a reasonable doubt? Instead, they're going to be faced with several questions. Was there a killing beyond a reasonable doubt? Was the killing unlawful beyond a reasonable doubt? Was the killing of a human being beyond a reasonable doubt? Was the killing by another person beyond a reasonable doubt? And was the killing without justification beyond a reasonable doubt? If any single one of these material elements is not proven beyond a reasonable doubt, then you must be found not guilty. This sometimes is the cause of trials taking a long time. The prosecutor must prove beyond a reasonable doubt that the victim in a murder was human. This doesn't take long in and of itself, and it seems somewhat silly, but every element must be proven. Common law and white-collar crimes. As we go over the following definitions, consider the strengths and weaknesses of the crime's definition. As you'll see, there is a good reason why most states do not use these exact definitions. The material elements will be bolded. Are there material elements that aren't in there that should be? Are there material elements that seem antiquated or don't apply to modern needs? Remember, every element must be proven beyond a reasonable doubt for a prosecutor to secure a conviction. Murder. Murder is the unlawful killing of a human being by another person without justification. If the prosecutor is able to prove a killing beyond a reasonable doubt, that it was unlawful beyond a reasonable doubt, that it was of a human being beyond a reasonable doubt, and that it was without justification beyond a reasonable doubt, but can only prove that it was most likely by another person, since there's a little bit of doubt about whether the victim accidentally shot himself, then the defendant must be found not guilty. There are several different types of murder, and every state's laws are different. Generally, first-degree murder is murder that comes with premeditation. Second-degree murder is without premeditation, but still with specific intent. Voluntary manslaughter also includes specific intent, but it is done in the heat of passion. The difference between second-degree murder and voluntary manslaughter is that the defendant had a moment of cool reflection to stop and consider that maybe killing people you're angry at is a bad idea. With voluntary manslaughter, the defendant lacks that moment of reflection and is not in control of themselves when they commit the murder. Involuntary manslaughter and felony murder are different in that they require only general intent. With involuntary manslaughter, you never intended to kill anyone, but you did intend to do something bad. Perhaps someone bumped into you at a bar and you decide to teach them a lesson by punching them. They fall, bump their head on the concrete floor, suffer a brain bleed, and die. You intended to commit a battery. You didn't intend to kill the person. You have committed involuntary manslaughter. The felony murder rule is controversial and exists in various forms in over 40 states. In some places, it is punished the same as with first-degree murder. Under the felony murder rule, if a person is engaged in a felony and someone dies in the process, then the defendant is charged with the murder of that individual. A felony in this case is not a literal felony, but rather a serious crime such as robbery, rape, kidnapping, aggravated assault, or similar crime. If you kidnap someone, stuff a dirty sock in their mouth, and toss them in the trunk to ransom them off, and that person chokes on your dirty socks or suffers heat stroke in the trunk, you will be charged for murder. You and your friends intend to commit an armed robbery on a grocery store, which results in a shootout with the police. If the police, who are notoriously bad marksmen, miss you and hit an innocent bystander, you can be charged with their murder. You've intended to commit a felony, armed robbery, and someone died in the process. You can be charged with their murder despite having no intention of killing them. Robbery. Robbery is the taking of personal property from another person or business by use of fear or force. In short, robbery is theft plus assault or battery. As you recall from the chapter on torts, many intentional torts are also crimes. There, we talked about how assault is putting someone in reasonable fear of imminent harm, and battery is an intentional, non-consensual touching. So if a person comes up to you on the street, points a gun at you and says, "Give me your wallet," they put you in reasonable fear of imminent harm, and then they took your wallet. Assault plus theft. If a person punches you in the mouth, knocks you down, then takes your wallet, they've committed a battery plus a theft. Both are robberies. Burglary. Burglary is the breaking and entering of a dwelling house at night with the intent to commit a felony. We have 4 material elements. Each one must be proven beyond a reasonable doubt. There are several reasons why no states use this definition any longer, but we still use it to illustrate the importance of carefully reading a statute. When the average person discusses burglary, they know exactly what they're talking about. A person goes into a house and steals stuff. In many cases, that's accurate, but every state's definition is different. Under the common law, you'd have to have a breaking and an entering. So you might be guilty of some other crime, but by this definition, if the door was open and you walked in and stole stuff, that wouldn't be a burglary. You'd only be able to burgle. I looked it up. That's actually a real word. Say it out loud. It's fun. You'd be able to burgle a home, not a business, and you'd only be able to burgle. I'm Come on, say it. You know you want to. You'd only be able to burgle a house at night. If you did all this during the day, it might be some other crime, but it wouldn't be a burglary. This is the first element most states have omitted from their penal code. This also begs the question as to what exactly a dwelling house is. Is a mobile home a dwelling house? Is a car a homeless person is living in a dwelling house? This demands a search into case law, which not everyone can easily do. Lastly, there is the requirement that the person is entering to commit a felony. In this case, we're not talking about a felony in the modern sense. Entering someone's house to get out of the weather so you can smoke some meth in peace is not what the statute is talking about. It's talking about other serious crimes like rape, murder, kidnapping, aggravated assault, etc. Most states include this element, but also add theft. Larceny. Larceny is simply theft. Larceny is the wrongful and or fraudulent taking of another person's personal property. State laws on larceny vary wildly. There is also larceny by trick, which is simply tricking the person to hand over the property you're stealing, which is often incorporated into most states' larceny statutes. Wrongful or fraudulent means that we're not talking about borrowing something. The accused knows what they're doing, so there is specific intent. Note also that you cannot, under this definition, steal real property. It must be personal property. Larceny is an example of one of the main challenges a prosecutor faces when taking a case to trial. The prosecutor must prove each element. The prosecutor must prove that the accused not only took the property, but that they had the specific intent to deprive the owner of it. Beyond a reasonable doubt, it must be proven that the defendant intended to keep the property, not that it was found or borrowed or anything like that. Proving someone's mindset beyond a reasonable doubt can be a challenge, but it can be done with the right evidence. Receiving stolen property. To be convicted of receiving stolen property, the prosecutor must prove that a person knowingly received stolen property and intended to deprive the rightful owner of that property. We have the words knowingly and intends, so we know this is a specific intent crime. If the person received stolen property, think a pawn shop, but they weren't aware it was stolen, then they have not committed this crime. If the person knows it's stolen and accepts it, but they're going to try to find the owner, they don't intend to deprive the person with title to the property, so they have not committed this crime. Arson. Arson is the malicious and willful burning of the dwelling of another person. Few states use this definition for several reasons. This requires the burning of a dwelling. Often, arson is done against businesses, frequently for insurance fraud. Just as often, especially if we're talking insurance fraud, arson is committed against one's own property. In either of these situations, that person could not be convicted for arson under this definition. Forgery and embezzlement. Forgery is the intentional creation or modification of a document to change its legal liabilities. Making a fake ID to get into a bar underage is forgery. So too would be signing someone else's name to a check if it is with the intent to change its legal liabilities. If your friend asks you to write their name on a check and then drop it off to pay their bills, even though you wrote their signature, it is not a forgery because they wanted that check to go for a specific place for a specific purpose. If you write their name on a check and buy something for yourself, you have now committed a forgery. Embezzlement is the intentional conversion of funds you're entrusted with to use for your own purposes. If you're an executive of a business and you take company money set aside for payroll to buy yourself a car, you've committed embezzlement. If I, as a lawyer, took money out of my client's trust accounts to buy myself something before I've earned the money, then I've committed embezzlement. Embezzlement often happens alongside forgery. Once the embezzlement has occurred, the person who did it needs to cover their tracks. Once they've modified ledgers or legal documents to hide their act, they've committed forgery. Bribery and extortion. Bribery is making or accepting offers of favors, gifts, or other things of value to induce or influence a person with legal authority to do what you want. The person making the bribe is guilty of bribery the moment the offer is made, regardless of if the bribe was accepted. The recipient of the bribe is guilty of bribery only if they accept it. This, of course, follows logically if you consider that if the recipient were guilty at the time of the offer, then ethically innocent people can be convicted based on the actions of other people offering them bribes. Extortion is when a person uses threats to secure some benefit. Blackmail is a form of extortion where the threat is to reveal private information. Extortion is seen in almost every mobster movie. The small shop owner shows up in the morning to find a brick thrown through their window. Later that day, some well-dressed gentlemen show up to offer protection from the ruffians that would have done such a thing. The extortion here is the implied threat that if the shop owner doesn't pay for the protection, that he's sure to find another broken window. Extortion can occur also from people with the lawful authority to carry out the threat. This is referred to as extortion under color of law. Imagine a health inspector shows up to your restaurant expecting a free meal or some other kickback as payment for giving you a passing grade. If you were to offer the free food for the passing grade, you would be guilty of bribery. If the health inspector demanded free food of you for the passing grade, that would be extortion under the color of law. Criminal procedure. Having discussed the material elements of some common crimes, we move on to discussing the process of applying criminal law. We'll begin with your first contact with a police officer and proceed all the way through the trial process to sentencing. As with everything we've discussed so far, there may be some deviation between jurisdictions, but most cases follow the general flow that you're about to see. Types of police contact. Every contact you may have with a police officer will fall under one of the following three categories: consensual contact, detention, or arrest. I will discuss each of these types of contacts and what your rights are during each. While it does sometimes happen that there is a flow from the consensual contact through detention to arrest, this process can go in any order or can begin and end in just one of the types of contact. Regardless of which type of contact you are in, there are two rules that will remain constant. Do not talk to the police and do not consent to searches. I'm not kidding here. The amount of people that I talked to that could have stayed out of trouble if they had just kept their mouths shut is staggering. A failure to follow one of these two rules will make your life and your lawyer's life more difficult every time. Consensual contact. A consensual contact is one that you have allowed to happen. You're consenting. The key element of a consensual contact is that you are always free to leave. You really should take advantage of that right, lest it elevate to one of the other two forms of contact. A consensual contact can be any number of things. It could be you going to hang out with your brother who's a cop. It could be calling the police for a problem you're having. It could be an officer at the gas station griping to you about gas prices. A police officer does not have to have any reason whatsoever to initiate a consensual contact with you. Many police contacts begin as a consensual contact. It is common for the police to call someone they suspect of criminal activity to come in for an interview. You are never required to do so, and you should not take them up on that offer. They sometimes suggest that maybe there's a misunderstanding and wanted to give you the opportunity to tell your side of the story. Do not do that. The contact might begin as friendly and consensual because they lack sufficient evidence to hold you. Alternatively, on the street, it may begin friendly and consensual, so you'll keep your guard down. If the police come in aggressively, you're much more likely to become defensive and ask for a lawyer or stop talking, both things they'd like to avoid. They are not required to tell you if you're under investigation, nor are they required to provide you an attorney. Detention. A detention is the next higher level of police contact. You have been detained and are no longer free to leave. If you are unsure what type of contact you're in, you can always ask if you're being detained. If the answer is yes, then you know you cannot leave. If the answer is no, then it's a consensual contact and you can leave. Sometimes instead of asking if they are being detained, a person might ask if they're free to leave. If the answer is yes, then it's a consensual contact and you can and should leave immediately. For a police officer to detain you, they need to abet a burden of proof called reasonable suspicion. This is a much lower standard than beyond a reasonable doubt or even a preponderance of the evidence. This doesn't mean that the officer needs to think you did the crime. only that a reasonable, there's that word again, officer could think you either did the crime or have some knowledge about a crime they're investigating. They need to be able to articulate why they think you need to be stopped. A simple hunch won't do, although a hunch is sufficient for a consensual contact. You are not free to leave, but that doesn't necessarily mean that you have been handcuffed. It could be something as simple as being pulled over. You see the flashing lights in your rearview mirror, and you know that you cannot just keep driving. You must pull over. It can be you being cuffed and sitting in the back of his car. It could be him telling you not to go anywhere while you sit against the wall. Your right to remain silent under the Fifth Amendment remains. You are not required to answer questions. You should not answer questions. Some states might require you to give your name and driver's license, but during a detention, you should expect to be questioned, and you should not answer those questions. This does not mean that you need to be rude. A simple, "I'm sorry, but I do not answer questions," is sufficient. You should not consent to any searches. If an officer can search your items, they will. You should not resist the search, but you should not consent to a search either. You should expect to be searched for weapons. This is called a frisk or a Terry search. We will discuss this exception to the Fourth Amendment in the chapter on constitutional law. Arrest. The next type of contact is an arrest. With an arrest, you are also not free to leave. That officer has met a higher burden of proof than is necessary for detention. Now he has probable cause that you have committed this crime. This is higher than reasonable suspicion, but still a relatively low bar and not yet as high as the preponderance of the evidence standard necessary in civil law to win at trial. You still retain your Fifth Amendment right to remain silent, and if you have not done so yet, it is imperative that you do so now. You can expect to be searched more thoroughly at this time. There are exceptions, but the default expectation is that for a person to be arrested, the police must get an arrest warrant. For an arrest warrant, the police must go in front of a judge, present the probable cause necessary for the arrest, and if the judge agrees, she will issue the warrant. However, most arrests are made without a warrant. For a warrantless arrest, the police must witness or gather the necessary probable cause on scene. In some jurisdictions, only witnessing the crime themselves is sufficient for a warrantless arrest. And in some jurisdictions, the police cannot enter your home to make an arrest without a warrant. There are some exceptions to this rule, however, such as crimes where the possibility of imminent violence or danger to others is present, or if there is a reasonable threat of destruction of evidence. There are many ways contact may progress. An officer with a hunch may make a consensual contact. The suspect does not take the opportunity to leave the contact and/or begins answering questions. During the consensual contact, the suspect might say something, giving that officer reasonable suspicion. Now, if they want to leave, they cannot if the officer decides to detain them. During questioning, the officer might gather more information or determine from the suspect's answers that there is probable cause to make an arrest. Perhaps the officer arrives on scene and witnesses the crime, arresting the suspect on the scene. Or the officer arrives from a 911 call and with reasonable suspicion in place from the call, such as the suspect matching the caller's description, begins with a detention, and, as the suspect sits quietly in the corner, gathers sufficient evidence from eyewitnesses to make an arrest. An arrest is not always required for a criminal charge. In some cases, the suspect may be issued a criminal citation and the case will proceed to arraignment, which we'll discuss shortly. The process from arrest to sentencing. Every jurisdiction is different, but most cases will proceed in a way that is substantially similar to what we will cover. Note that if a person is not actually arrested, but given a criminal citation instead, the booking process will be skipped. Grand juries. A grand jury is used in felony cases only. Many states do not use them at all, but several states and the federal government often use them for serious crimes. A grand jury is a very unusual sort of hearing that is closed to the public. In many cases, the defendant is unaware of the hearing in the first place. In no case is a defendant given the chance to defend themselves or have an attorney present to see the proceedings. A grand jury hearing includes 16 grand jurors and the prosecutor. There is no judge or defense attorney, so the prosecutor's statements and evidence are unchallenged, making an indictment easy to secure. Former Chief Justice of the New York Court of Appeals, Saul Wetzler, is well known for saying, "A district attorney can get a grand jury to indict a ham sandwich." If 12 of the 16 grand jurors believe there is the lower standard of probable cause, then the defendant is indicted of the crime and an arrest can be made. A charging document called an indictment will be filed with the court. In narrow cases, an arrest can still be made without an indictment, but it is rarely done because a prosecutor unable to meet that low standard unchallenged and only needing to convince 3/4 of the grand jury will surely be unable to get a unanimous conviction at a trial. Booking. When a person is arrested, they're taken to the jail. There, they will be thoroughly searched. Your personal property will become a bailment. As you recall in property law, a bailment is when a person, in this case the jailer, becomes the bailee with possession, but not title, to your property. There you will be in-processed, which includes getting your mug shot and fingerprints taken. In some jurisdictions, they'll also take a cheek swab to gather your DNA. This is where you'll get the opportunity to make a phone call. Some crimes will have bail amounts preset, and you'll be able to post bond. In other words, pay your bail amount to be released as you await your arraignment. If your charge does not have a preset amount for bail, or you cannot afford to post bond, then you will remain in jail until your arraignment. Arraignment. Your arraignment is your first appearance in court. Present will be you, the defendant, the prosecutor, the plaintiff, and the judge. If you've already hired an attorney, they will also be present with you. The judge will inform you of exactly what you've been charged with and what the maximum possible sentence is. The maximum sentence is not necessarily the sentence you will receive if convicted, only the maximum possible sentence. As stated earlier, for an arrest, there must be probable cause that you committed the crime. The prosecutor will have to recite to the judge why they believe you committed the crime. If the judge disagrees that there is sufficient probable cause, then you must be released, but that is unlikely as the burden is still quite low. The judge will then ask you to render a plea of guilty or not guilty for what you've been accused of. And you will plead not guilty. If you plead guilty, you will lose all control over the case and it will immediately proceed to sentencing. But that is not going to happen because you will plead not guilty. The judge will then determine if you can be released on bail. The point of bail is to serve as security that you will return to see your case to completion. If you return, at the end of the case, the money you paid for bail will be returned to you or forwarded to pay any fines that you must pay as part of your sentence. The judge will base bail on several factors, such as your financial means, your ties to the community, and what you've been charged with. In short, the judge is trying to set bail in such a way that you will not run away and avoid finishing the case. With minor charges, the judge may release you on your own recognizance. This means that you're being released on your honor and your promise to return. With serious enough charges, the judge might deny bail altogether. The judge will determine how you are to be represented. If you wish to represent yourself, the judge will begin to treat you as an attorney. This is referred to as being pro se. This is not advisable for reasons previously mentioned under civil law. If you wish to hire a private practice attorney, you'll get the chance to do so. If you wish to have a public defender appointed, in most jurisdictions, the judge will make a financial determination as to whether you are eligible. For most places, there is a financial threshold that must be met to be appointed a public defender. The last thing the judge will do in the case of a felony is to set the date for a preliminary hearing, and the defendant will be given a criminal complaint. The complaint will look like the complaint in a civil case, but will specifically outline the charges and maximum sentence. Preliminary hearing. Preliminary hearings are for felonies only. They will be used in situations where an indictment has not been issued. Its purpose is not to determine guilt or innocence, but rather to ensure that there was sufficient probable cause to justify charging the defendant with a crime. If there is sufficient evidence, the defendant is bound over for trial. Preliminary hearings are like a miniature bench trial. If you recall, a bench trial is one with the judge serving as both the finder of fact and arbiter of law. Both the prosecutor and the defendant are given the chance to present evidence in their favor. Most preliminary hearings are used for less serious felonies. If the judge determines that there is probable cause, the court files an information which looks like the criminal complaint. The defendant is bound over and the case proceeds. If the judge determines that there is insufficient probable cause, the charges against him are dismissed. Most preliminary hearings occur within 2 to 4 weeks of the arraignment to ensure defendants are not held in limbo for frivolous charges. If a defendant was denied bail at their arraignment or was unable to pay it, then they've been sitting in jail this whole time, making it important for the preliminary hearing to happen quickly. Pretrial conferences. Several pretrial conferences will occur during the case on the way to trial. I'm sure you're tired of hearing this by now, but they will look differently depending on the jurisdiction. In some places, the prosecutor and the defendant's attorney will be able to sit down privately and discuss the case. They will discuss possible plea bargains, evidentiary issues, issues with witnesses, or other matters. In other jurisdictions, the conference will occur quickly in open court in front of the judge where these matters are discussed. The judge will calendar hearings and resolve disputes. The primary purpose of a pretrial conference is to ensure the case is proceeding and the parties are not simply dragging their feet while the defendant's liberty is at risk. The defendant is entitled to a speedy trial under the Sixth Amendment, and the judge needs to ensure this is happening. Things your lawyer is doing. Throughout this process, the defense attorney has been busy. Some of the documents he has filed will be familiar from our chapter on civil procedure. Among the documents filed will be the notice of appearance, request for discovery, and various motions. The lawyer will be reviewing and gathering evidence, preparing witnesses for trial, and negotiating outcomes with the prosecutor. The notice of appearance is the document that informs the prosecutor and the court that you have an attorney representing you. If you hired an attorney prior to your arraignment, often that document will also include a plea of not guilty. Many times this document can complete all the requirements for an arraignment, so they do not need to have one. The request for discovery is like the one filed in a civil case. The major difference is that a criminal discovery request demands all evidence the prosecutor has regarding the case. While this does include specific requests, the prosecutor is still bound to hand over all the evidence in the case, regardless of if it helps or hurts the defendant or if the defendant asks for it specifically. A failure to do so can result in sanctions against the government and the prosecutor. Or in some cases where failure to disclose evidence is severe enough, a case might be dismissed. There will be several motions filed in the case as well. One of the most common motions is a motion to dismiss, where the defendant's attorney alleges there is some sort of legal matter, such as a disagreement over a statutory interpretation that demands the evidence be dismissed as a matter of law. Lawyers might file a motion to suppress evidence. With this motion, there is some issue in the rules of evidence, or perhaps the evidence was gathered in violation of the defendant's constitutional rights. Under what is called the exclusionary rule, evidence that is illegally gathered cannot be used by the prosecutor. The attorney is asking that the court order the evidence be suppressed. That is, that the judge rules that the evidence cannot be shown to the jury or used in the trial. During this process, both attorneys will be discussing the case with each other and perhaps negotiating a just outcome. They may be discussing calendaring issues, incomplete discovery, evidentiary issues, or potential plea bargains. Plea bargaining. Most cases result in a plea bargain. This is when the defendant and the prosecutor agree on a potential sentence. This could involve the prosecutor amending or changing the charge from one thing to another, such as amending a DUI to the lesser charge of inattentive driving in exchange for a guilty plea. This could involve dismissing some charges if the defendant pleads guilty to the remaining charges. This could be the result of the prosecutor agreeing to recommend a specific sentence in exchange for the guilty plea. The prosecutor doesn't get to determine the sentence, but judges often follow joint recommendations, and some written recommendations include provisions permitting the defendant to withdraw their guilty plea if the judge does not accept the recommendation. There are many reasons why a prosecutor might offer a plea bargain. In some cases, the prosecutor might be overwhelmed with the number of cases in front of her and simply cannot take every case to trial due to a lack of time and resources. In other cases, the evidence might be weak, so the prosecutor agrees to a plea bargain because getting a lesser penalty is better than possibly losing at trial and having someone they believe is guilty walk free. Evidence might be weak due to a successful motion to suppress evidence by the defendant. And, in some rare cases, a prosecutor might dismiss or amend charges in the interest of justice because it's a better or more just outcome for the case. This is very prosecutor dependent, as there are some very good prosecutors who care deeply for justice and others who treat a case more like a competitive game that they need to win. There are many reasons why a defendant might accept a plea bargain. First and foremost is the possibility that the defendant is, well, guilty of the crime, and a plea bargain permits him a little bit of control over the outcome of the case. Most plea bargains result in a better outcome than is likely to happen if the case proceeds to trial and the defendant is found guilty. Other reasons why a defendant might plead guilty is because, despite his innocence, the evidence does not look good and he's likely to be convicted anyway. Consider a defendant being charged with murder who is certain it was a matter of self-defense. The prosecutor might make a lenient offer for a guilty plea. If the matter goes to trial, there's no guarantee how the case would go. The risk might simply be too high. In addition to the risk that comes with possibly being convicted, it's the financial issues that come with paying lawyers for dozens, if not hundreds of hours preparing for trial. Lawyers aren't cheap, and even if a person is found not guilty, the financial burden might be worse than simply accepting a lenient plea. As you can see, there's a lot of room for reform within the criminal justice system. If the defendant accepts a plea offer, the case will proceed to a hearing where the defendant changes their plea from not guilty — remember, you pled not guilty at the arraignment, didn't you? — to guilty. The judge will then set a date for sentencing. If no plea offer is accepted, the case will proceed to trial. Trial. Very few cases make it to trial. Between federal and state court, trials only occur in about 2 to 3% of cases. This statistic is borne out in my own practice as well. Overwhelmingly, cases result in the defendant accepting a guilty plea. The process of a criminal case follows closely with a civil case. The primary difference is with the jury and the burden of proof the prosecutor must meet. For a defendant to be found guilty, the prosecutor must prove, beyond a reasonable doubt, each of the material elements of the crime the defendant is accused of. Following the jury instructions after closing arguments, the jury will discuss the case and return with a verdict. In most jurisdictions, misdemeanors will consist of 6 jurors and felony cases with 12. The jury will return and render a verdict of guilty or not guilty of each crime or count if there are multiple charges against them. The jury's verdict must be unanimous. If the defendant is found guilty, the case will proceed to the sentencing phase. For most misdemeanors, sentencing will occur at the end of trial. For most felonies, a sentencing hearing will be set for the future. If the defendant is found not guilty, then he will be free to go. Under the Fifth Amendment, a defendant cannot be tried a second time for the crime, even if they admit they did it after being found not guilty. Note that the defendant is not found innocent. The jury is not determining that the defendant did not do the crime. The jury is saying that the government has failed to prove beyond a reasonable doubt that the defendant did the crime. If the jury cannot come to a unanimous decision, there is a hung jury. The effect of a hung jury is like the defendant being found not guilty. The defendant can leave. However, unlike with a not guilty verdict, the prosecutor can decide to charge the defendant again, and the case begins anew. The Fifth Amendment only protects you if the jury says you are not guilty, not if they cannot decide and end up with a hung jury. It is a common practice at the end of a trial for an attorney to request that the court polls the jury. This means that they're asking each juror to confirm their decision. If the prosecutor sees that 10 or 11 jurors said guilty, but only 1 or 2 said not guilty, the prosecutor might think it's worth it to try the case again. But if several jurors believe the defendant was not guilty, then the prosecutor might decide not to retry the defendant, considering it unlikely that she'll secure a conviction. Sentencing. Once a defendant has been convicted of a crime at trial, or the defendant has pled guilty, either at the arraignment, which you will never do, or later when they accept the plea offer and change their plea, the case will proceed to sentencing. It is the job of the judge, not the jury or the prosecutor, to pass sentence. Even if you have a written agreement with the prosecutor, as a plea agreement, the judge is not bound to accept that offer, although she most often will. As previously mentioned, there are some rules in place that will ensure that the defendant can withdraw their guilty plea if the judge doesn't accept the agreed upon sentence. This is another good reason to ensure that you have an attorney help you in your case instead of representing yourself. An improper plea might not give you the necessary protections that a Rule 11 agreement has. For most misdemeanors, the judge will immediately move to sentencing following the trial, or at the hearing where the defendant changes their plea. For most felonies, the judge will postpone the sentencing for a later date. The judge will order a pre-sentence investigation report, PSI. This is an incredibly expansive report covering dozens of pages. It will talk extensively about the defendant's background, his family, mental health issues, friendships, his education, substance abuse issues, employment history, and more. It will then run this information through a battery of tests that calculate recidivism rates. This is the chance that the defendant will reoffend. It will also calculate what sentences other judges have given in similar scenarios to ensure fairness in sentencing. The point of a pre-sentence investigation report is that the judge must pass sentence but truly has no idea who the defendant is. It is unlikely that the defendant has spoken much to the court. Under the Fifth Amendment, the defendant is never required to testify as a witness, and in most cases a lawyer will not allow them to do so. This means that the defendant has primarily just been a person attempting to look clean and presentable and has not said more than a word or two. The judge needs a way to determine who this person is so she can pass a proper sentence. During sentencing, the victim, if there is one, or their family will have a chance to make statements to the court to influence the judge's decision. The defendant will have a chance to make a statement, as will his friends and family who wish to testify to his character. Finally, the prosecutor and defense counsel will have a chance to make their thoughts known and possibly make sentencing recommendations. The judge will take all this into advisement and pass sentence.